are you? It's nice to see you back.
Thank you. Lots of travelling. Great to be out with clients, but I don't like being held up in airports, Andrew. I'll tell you that much.
No, we bought the best airline ticket we could for you. So.
I'm here. I'm happy. How's your week been?
Look, fun week. Really busy, interesting stuff with clients. Some nice strategy work, not just the distracted end of the work, which is always exciting as well. And like you, being out with clients, post whatever COVID, whatever it was, to actually be out with clients. With Christine and Scott, who we were out with last night, it was just a lovely time to be around and to actually share their experience of what's happening in their business in a way which is more intimate than a Zoom call.
Yeah.
What about you? What are the challenges you've had this week?
Oh, it's been quite a diverse week, really interesting. So been out to regional Victoria to deliver some management trainings. That's always fun, and being able to walk away and have people say to you that makes so much sense and really is very helpful. So that's always nice. That's the fun part. So I've just flown back from working through a national enterprise agreement. So that's fun in a different way. But we're progressing really well there too. And over this week and next week, a couple of complex investigations. So just helping a couple of organisations there work through some really what appears to be some really tough scenarios. But look, that's the reason why they've raised their hands and got help, even though they have the resources internally. So we spoke about that previously in terms of knowing when to engage external support. So it's a full week. Next week will be full, but I've got new shoes.
Yeah.
So I'm happy.
And they're Australian shoes.
They're Australian. Oh, really? I finally bought myself a pair. So
that's very good.
Yeah, they keep me happy. Happy feet.
We'd be able to do the Hugh Jackman walk around the office. Just be able
I don't even know what that walk is. I've got to Google it. Is it really quite a distinct walk?
It's quite a distinct
walk. Okay.
You've got a distinct walk, which is 300 miles an hour. All right. Well, look, we're pretty close to being ready to kick off now. So I might just give you a bit of overview of what I'm doing today, and you can talk about what you're doing.
Sure.
We still don't have a name for your section, by the way. We've had a number of suggestions. We can keep those coming in. We're going to go and have a look at some. It's actually going to be quite a legal week, and I'm sorry about that. So the first case I want to talk to you about is Panini and Roy Hill. This was a guy who was put on a performance plan. It's a really important issue to understand. Good process really matters. He gradually improved his performance over the first 3 months of the performance plan, and on the last one, he actually performed okay. But they extended it for another 3 months because they wanted to be sure. On the fourth one, which on the fourth month, he actually underperformed quite significantly. Now, the performance improvement plan was really clever because what they did is they only put in the performance improvement plan about 80% of what he was actually required to do. And can I say this is a really important, and Karen can speak to it more shortly, but it's an important thing to do. When he failed, he then refused to sign it. And here's another thing, you don't get people to sign performance improvement plans because you're performance improving them. And then he resigned and said he was forced to resign. And it went off to the Fair Work Commission, and the Fair Work Commission then applied a High Court decision of Milford, of Coal Supply in Milford, which basically said if you bring a general protections claim asserting that you were terminated by employment, there is a jurisdictional argument you can have in the Fair Work Commission, that is before it goes off for trial in the federal court, as to whether it was a termination by the employer. And the Fair Work Commission, they said, no, this was definitely a resignation because you could see that there had been a fair and transparent process all the way through performance improvement plans, and it is a legitimate thing to improve people, and the plan was a reasonable plan in the circumstances. So, Karen, the two things that jump out of this to me is how do you actually scope out to do a performance improvement plan, and this idea of getting people to sign things like warnings and performance improvement plans? What's your view on those?
I don't think you're signing an improvement plan. The plan is the plan. The plan is to do your job. So unless we're signing off something every day to do our job, I don't think we need to be signing off on such a thing. So if you're doing that at the moment, consider reviewing your processes or your...
Because you're giving the lawful and reasonable direction.
Absolutely.
What a performance plan is saying, this is what I require you to do. It's actually lawful because it's within your job description.
Absolutely.
And this is the level of expectation we have. It's part of a counselling towards discipline process that's arising. You don't ask people to thank you for that.
No, that's not. And the other thing I'd say is also remember performance plan. Don't predetermine the outcome. Okay? Again, we're still seeing it, Andrew. That we're we're going to try and terminate somebody, or they're no longer good at their job, so let's put them on a performance plan and get them out. Because that's not how or what performance plans are meant to do. They're performance improvement. They're there to support and give people clarity to be able to do, to perform their work to the quality that we expect. And it may result in that there's some disciplinary action, some counselling, or it may mean that they're no longer suitable for the work, and we manage that. But certainly that's not what we walk into it with.
No, and I look at every day people say to me, look, everyone's got sick of him. What do we do? Can we make him redundant, or can we performance manage him out? And so before we get to that issue, the first thing is you must manage people immediately, not late.
Yep.
Okay, because then everyone gets in their frontal lobe, I just got to get rid of them. And that speeds up this process. But courts can see that speeding up of the process, and they can see it's procedurally not fair, and they can also see the predetermination. So please, great cases, just something to jog your mind. Next case for our safety people is Safe Work Australia and HD projects. A really simple case on contractor management. I'm raising this again because there is this continual crap around the fact that you can actually delegate responsibility to a contractor. And I just want to say to you, it is what I just said, it's crap. HD were involved in managing the lifting of panels on a work site. So they were a subcontractor to a principal contractor on site. But for the purpose of this process, they were the principal contractor of elevating these panels and putting them in place. They used a business called All Cranes, which was the crane company who lifted them. HD set out a proper SWIMS, which was their obligation as the contractor in charge of it, and that SWIMS said two things. One, the person who's connecting the panel up for lifting on the crane has to be skilled, and that was HD's responsibility. That was a dogma, they had to have to do that. And they also said in the SWIMS, as to where you slew the panel to lift it up, it had to be an exclusion zone, and that was All Cranes' responsibility. Now, neither of those things happened. HD used a labour hire employee to do that work without checking whether he was certified. They actually supervised him doing it, and he wasn't competent. He didn't do a competent job. The crane company allowed the crane to slew over an area where there were workers. The panel fell and damaged two people quite severely. Now, the crane company got $200,000 fine because clearly lifting a panel over the top of people is an inherently dangerous and stupid thing to do, whether you have a SWIMS or not. But HD didn't escape. They got $170,000. Not just for the use of the non-dogman labour hire, but particularly for failing to follow their own SWIMS.
Their own SWIMS. That's the ridiculousness of it.
It is. And I'm not sure even ridiculousness is actually a word, but because you're so tired, I'm going to let it go. All right?
That could be a word. Somebody help me.
Come on, someone find another word for ridiculousness. All right, now the next case is probably one of the ones that I want you to think about more when you're trying to control the internal narrative. Remember, today is a story about internal narratives. When we started off with the first case around performance improvement plans, what Karen said is, don't create that predetermination. In Hawke and Linfox, we have another case where the Linfox driver who suffered an armed robbery, got PTSD, and a level of suspicion about the nature of his ailment happened, and so they actually organised some surveillance of it. This is covert surveillance, so in New South Wales and Queensland, you'll know covert surveillance about putting someone on notice is also unlawful while they're being an employee. But part of this was they observed him doing these amazing things for a guy with PTSD, like walking to Sunday school, like driving a car, and he had a photo shoot in the park. And as a result of that, they formed the view that he's putting it on. And of course, the guy put in a workers' comp claim in relation to the psychological stress that he suffered by the surveillance. And not surprisingly, the tribunal said, look, don't you know better than to do this? Don't you know to actually go and understand what PTSD is before you start distrusting? People with PTSD often walk. They often drive cars. And the photo shoot seemed a bit out there, but we've had cases like Marshall and the Department of Meteorology where Marshall, when he was on stress leave, when he worked for Beauty and the Geek, and everyone said, oh, that's just outrageous, he's on television, but actually was helping him. So I guess what I'm trying to say about this is, before you start being suspicious of someone behaving badly, reflect a little bit about what is the nature of the problem has. And when people can walk and have coffee, that's nearly everybody. Now, is there something you just saw come up, is it?
Yeah, no, Janelle's just sent a link to the Webster, also a dictionary of some sort about the word ridiculousness. Yeah.
Stop it, Janelle, don't support it. So the case around the foolishness of surveillance we've talked about before, which is Canaan and DP World, which is when they had a bloke who couldn't work as comp claim for an injury to his back, and they were looking over his fence, trying to see what he was doing. He was working on his car, and they then said, it's a fraudulent claim and terminated. And the court in that case said, well, it was unlawful surveillance, so you shouldn't be doing it. But it's so dumb because you didn't ask him whether he could do it. He could do it, and some of them caused him a little bit of pain, but it's his passion in life. He couldn't do his work. His doctor said he couldn't do his work. So remember, when the doctors tell you something, go and check the doctor. That's fine.
Yeah.
But try and avoid surveillance unless it's absolutely necessary.
So two things in that quickly, Andrew. One is in terms of where people have got a condition, I think we need to spend more time understanding what that condition is and what that looks like and how that may impact people and how that looks different from person to person potentially. Seek to understand.
Yeah.
And the other part is you mentioned earlier in terms of having a good reason to conduct surveillance. So like what would be a good premise for having that done?
Well, look, we did surveillance on a fellow only about 3 months ago who had a severe knee injury and couldn't be lifting, and we got a photo of him playing football on the weekend for a team. So we conducted surveillance and we sent off to the doctor and said, for a person who says that he has these, could he be doing these things? And the doctor said no. Okay, so there's a good example. But the other part to remember is we all get caught up in diagnosis. And of course, what you suffer from may be a diagnosis, but it's how it affects you that's important. So there's two parts about it. One is know what is the issue the person suffers and don't get entrapped in conversations around diagnosis. Because people have unconscious bias against things like PTSD. They go, it's all bullshit.
Yeah.
And an industry like Linfox, which use vehicles, there's a whole lot of testosterone-driven people who go, it's just weak, you know what I mean? So be careful in those environments with that unconscious bias. Look to what actually the person suffered, find out what it is, and stop laughing. I'm trying to be serious, all right?
Yeah.
I know you haven't slept, but give me a break here. Okay. So there you go. I've answered your questions. Now we're over to you, and Soph, if you could bring up the mentally healthy workplace that Karen's going to talk. Well, that's what you got, mentally healthy.
Did I not sleep or did you not sleep?
I didn't sleep a lot either, and you're killing me. Okay.
All right.
Thanks, Soph.
Okay, so last week I mentioned to you that if I can get my brain together, the week prior we had spoken about mental health at the workplace, and I said in terms of let's see if we can put something together by way of creating a mental health plan for the workplace. Now, there are some resources that you can search for online, but I thought rather than create a template as such so that you can populate it and create that plan for yourself or your organisation, I thought that wasn't terribly going to be helpful to you, but rather draw you to the factors and the elements that you need to consider in terms of when you're designing a plan for your workplace. So let me first say though that there's many more elements here that you can add, but all things that we do at the workplace, including mental health plans or any type of change, it's all underpinned by leadership. Okay, because you can have the best people, the best process, the best framework. It's all leadership.
And the safety law that sits behind it, which says you must do everything reasonably practical to monitor people's health and provide a safe workplace, which means reasonably practical. We'll just do it one more time for fun, which is identify potential hazards that exist, determine the level of risk that goes to those, introduce controls, allocating resources to the organisation to ensure they eliminate or mitigate those risks. So that's just to keep reminding people what that obligation is.
That was fast. Yeah.
So I'm awake now.
So in terms of a mentally healthy workplace, things to consider around workplace design, creating an environment that's positive, ensuring that managers, we have leadership support, but also support peer-to-peer, and also recognising in terms of mental health as a genuine, it's something that is not removing the stigma around mental health, because that's still, even though there's a lot of work done there and acceptance and recognition of that impact, there's still this kind of, do we touch it, do we not touch it? Is it normal or not normal? So there's that. And also really with the amount of change that we're all normalising to now, is that another word, normalising?
No, that one is a word.
Okay, that is a word.
Okay, you can look that up too, but definitely that's a word.
So organisational change, it's something that's going to continue to happen. So how is it that we engage with people meaningfully, allow people to feel safe? Because if we don't, then we just create this risk around creating anxiety and workplace-related stress. So it was just a slide to help you touch on a couple of points there.
And can I just say, look, around organisational change, certainty is the key. I know the world is uncertain and we can't create all certainty, but what really damages workplaces more than anything is people not understanding what is their job, how to do it, and what the future looks like for them.
Yep.
So please focus on that as a key part to having a healthy workplace.
Absolutely. Now, moving on to HR governance, because that's what we said we'd put together this week. Now, HR governance structures, some organisations have them, some don't, but those who do would understand, and for those who are considering, the reason why we have a HR governance structure in place is to help ensure that there's a framework for maintaining or to testing the integrity of our HR processes, our policies and our practices. And the reason why that's important is to ensure that from a people performance, culture point of view, that we're maximising, optimising our human capital. And that in turn helps the organisation to be able to deliver on its strategic objectives. So that's kind of a high level kind of a statement there in terms of why it's so important, why do you do it? It's really checks and balances, isn't it, Andrew?
It is.
So with that, in terms of you haven't got one in place, okay, and there's no one way of doing this. I've really broken it down for you in terms of considering, well, what is it, why, who, how, when. So the elements are there for you in terms of understanding. Really, it comes down to creating HR having what is HR's role and its authority, creating a framework that suits your business and reflects the operational infrastructure that you have, having the right capability and resourcing to be able to support just not the framework, but people in the right places across the organisation to do all the right things, having controls in place so that when things go wrong or don't seem right, you're able to pick that up and manage it. So they're pretty much that's and managing and monitoring as well, which is something is just a checkpoint from time to time to make sure that everything's above board. But again, Andrew, leadership. You're not going to have.
It is. And look, remember when I talk about safety systems, that systems are still what we're talking about in HR, which means having a plan.
Mm-hmm.
It means ensuring that you have processes that execute that plan, that you have training that's competency based, that you have supervision skills to actually manage that process, that there's a monitoring part that comes out and then you report. And they're the 6 elements of both HR and OHS systems. And without those elements, it actually doesn't work, it fails. And what happens then is HR intervene and start becoming operational rather than being the person that tunes the car, make sure it's running properly for operations.
Mm-hmm. Absolutely.
All right, well, look, let me talk about in the seconds that are left after that, Karen. The case that I want to talk to you about today is an HR governance nightmare in some ways. One of the major problems in HR is it creates processes that are then executed in a template or process-driven fashion without being given a lot of thought. And often it's the operational people who come in and meddle and they stick a new piece in a contract or they make promises that can't be kept because I want Karen to work for me, so I'm going to tell her, look, Karen, you can do this, your wage is going to go here, you'll have bonuses here. I negotiate all those things and I stick them in a contract. But I use a template contract. So I've got clauses that should have effect and then I've got new clauses that I've just stuck in there, okay? Or my template contract's meaningless because actually there's errors in it and I'm now making hundreds of errors in the same template contract, so I don't read them every time. So what I wanted to go back to is a case in 2006, and I was still an old man in 2006, which is Walker and Citigroup, where Citigroup found this chap called Walker, worked in another financial organisation. They wanted him, they offered him $450,000. They said, come and work for us. You'll get this great wage, we'll bump your pay up, we'll give you a bonus the year after you start. And they inserted that into the contract. And they made a number of representations about doing all these things for him and making promises, which actually were hyperbole. They were things that they were trying to do to induce him to come to work for them. Just before he was about to start work, they found out that he wasn't the calibre of person that they wanted, so they gave him notice under the contract. And he brought a claim and he said, well, I've done nothing wrong. You've made me an offer and promised me these things. I want you to, and you've damaged my career terribly because it takes at least a year for me to find another job at this level. But you've also taken me out of my trajectory of where I was going. So you were my next step up, and now you've flattened me like this. What the court said is that specific words entered into contracts will have a higher weighting than words that already existed. Therefore, if you're going to terminate somebody and you said you're going to pay them a bonus, clearly any termination had to be on cause. Even though it said you could terminate with 3 months' notice, it had to be on cause because you're going to pay him a bonus. So something had to trigger you terminating him because you put that specific clause in. And they said, look, he's going to work for it. He would have worked for another 4 years, so we're going to give him $2.5 million damages. And the other thing they said is you made these representations, which at the time of making them, you didn't have any proper basis for knowing they were true. They were hyperbolic to try and induce someone to come and work for you. And when you did that, he relied on those. And that's under competition law, that's misleading and deceptive conduct. And so those damages were confirmed on 2 different grounds. And I guess the reason I want to tell you this case is this is a common issue when I'm dealing with people when they're moved up a job, or when we hire someone and we're desperate to get this key person and we make the extra promise, you'll be partner in a year, you'll be reporting directly to Karen. In fact, you won't. You have the governance responsibilities managing this unit, but you actually don't. And there is a series of cases that come after it. And what they say is that when you hire someone, you're normally hiring someone on the way up. Does that make sense? By your action, if you don't deliver what you promise, so their capacity to earn where they were going is reduced because they've knocked off their gradient and therefore recruiter treats them as a lower level recruit on the next time. That difference where they went off to where they should have got, that's the damages. So really, really interesting case. Last part of that case is, and I just raised this, when that happens, the law of contract says, if you make a promise that you don't deliver and it's significant to the contract, you're repudiating that contract. And that employee can accept that repudiation. Okay? And if they accept it and it's a proper repudiation, then they're not bound by their restraints. And that's a case called Crow-Horwath and Loan. So can you see how important contracts are and how important the representations are before, and why HR must govern offers of employment to keep that discipline around it and to fact check what are the promises that are being made. And remember, you've often got a recruiter out there who's making all sorts of promises for you as well, and they're your agent as a matter of law. So Karen, your thoughts on that?
My thoughts is, and particularly, you mentioned that you see this a lot with people going up to on the way up or moving to the next level. In the case that you referred to, it makes me think, well, what should we have done aside from just the contract and getting all that right? There should be a plan in place, a really open discussion that's two-way around. So what is it that you're going to do in terms of what are some of the key milestones, what are some of the objectives that we're focused on in the next 12 months in terms of you being able to be able to deliver and for us to be able to get to where we want you to be. And, do you know what I mean? So
no, look what you've built into our business. So Karen has operated as our CEO for a long period of time to build structure behind our business. So for me, to all the leadership group, we have our 3-pillar discussion fortnightly, which is, what are you doing for wellbeing? How's it going personally? What is the key business objectives are you hitting? Everyone has a business plan that sits beneath it. And for our young solicitors, we build business plans to show what their trajectory is and what are the milestones and what are the behaviours we expect them to reach the level. So they're getting that feedback. They get a weekly feedback, which is a 10 or 15-minute discussion, but they have a monthly feedback coming out against their business plan where we resource. Now, we do that because we want better performing people, but it also means no one can ever point the finger at us and say we made a promise we couldn't deliver.
Well, that's exactly right.
And that's called authenticity. That's what you want with your employees. You want that level of authenticity that sits between two people that has honesty. Now, we've really gone over time, so we're going to race into a case study which is by itself a complex case study. So let's go, Soph. You've saved us once and made us on microphone. Save us with a case study. Transfin boat builders have engaged a recruiter, Quick Catch, to find a new marketing manager. They are offering $180,000 plus super for a national marketing role. Jenny from Quick Catch headhunts Maria from Transfin's competitor. Maria currently reports to the CEO, is paid $160,000, major competitor in Victoria, and has a team of 4 working for her. The offer from Transfin is silent on who the role reports to. Jenny speaks with the CEO of Transfin and explains reporting is a big issue for me. The CEO, Barry Cooter, agrees she could report to him. Sorry, I know it's a bad joke. They speak about the incentive plan. Barry says he should deliver an extra $40,000 above her current incentive scheme. She earns about $100,000 at the moment, and explains they'll be going international in the next 2 years and she could head up that area in marketing if she succeeds at a national level. Maria accepts the offer. It says the place of the contract is New South Wales and has an onus restraint of 2 years. As a matter of law, 1 year would be enforceable. Termination clause is a bland clause allowing either party to terminate with 6 months' notice. Let's go to the poll. Sophie, the poll. Sophie, poll. I think we're having technical problems.
Are we?
I'm not sure. Oh, there's the poll.
I'm launching it.
You're launching it. Sophie's telling us you're meant to launch it. She's right. We haven't done well technically, have we, Karen? I've got a hand in this, I know. Well, dinosaur paw, actually. I think dinosaur paw. So we've got a bit of time because this is a complex question. I'm sorry we didn't launch that. I'm sorry we didn't have any volume either. Read the second half of the question. Is there a second half? I don't think there is. Oh, I see. There is a second half of the question. Look at that. When Maria arrives at Transfin, she discovers that she reports to the National Head of Sales, an executive member. Of the 6 employees who deal with marketing, 3 report to her and the other 3 report direct to the National Head of Sales. She also learns the bonus plan is a discretionary policy with no milestones and a history of paying no more than $40,000. Third, the history of developing an international business is a pipe dream. Maria raises her concerns with the CEO, says not to worry and just wait around a few years. Everything will work out. 4 days later, before her first paycheck, Maria sends a letter to the CEO stating, I refer to my representations made to me before commencing. I accepted my employment on the basis of those representations and now appears they are untrue. This is a repudiation of my contract and you and I accept it. Transfin received a letter from the lawyer seeking damages for the breach, claiming 4 years' wages at a high rate and $180,000 plus 140 bonus per annum. And I am the world's largest bum, so can I now apologise for that? And Sophie, you were right, I was wrong. I don't know much more accountable I can be for being a bum.
I'm just I want to get the audio for that later and just replay it.
Well, you could practice yourself.
No, okay, all right. Actually, my husband would agree with that. I think he's not tuned in this morning.
Sorry, Michael, if you're not there, I'm fighting for you.
All right. Okay.
So I think we're pretty close. Everyone hadn't read the second part of it, but are probably right anyway, and we are running out of time, so I'm going to respond to them.
Mm-hmm.
So we give them 10 more seconds.
Okay. 5, 4, 3, 2, 1. All right, it's more than half the group.
Okay. Well, guys, I'm sorry for that stuff up, but the first questions are the misrepresentations or pre-contractual promises of breach of law allowing Maria to make a claim? So there's a couple of things that sit in this. There are misrepresentations, and if misrepresentations are objectively untrue at the time at which they're made and someone relies upon them, then it's actionable, okay? So yes, in respect to the misrepresentations around international, around all those sort of things, clearly untrue at the time they were made. There is also a legal term called a pre-contractual warranty or promise, which means, Karen, come and work for me at Found. If you do that, then I promise you, you'll have your own car.
Mm-hmm.
But the car is not part of the contract. But you wouldn't have entered into the contract without the promise of the car.
Mm-hmm.
So once again, it's a novel legal concept, which means even if you have an exclusivity clause that exists in an agreement that says this is the sole source of legal obligations, it doesn't get around pre-contractual warranties, because what that says is, well, that's true in respect of the contract, but the person would have never entered into it but for those warranties and promises that were made. So you can see in this case, there are both misrepresentations, okay, and you can exclude a misrepresentation in a contract by having what's called a representation clause that says that this contract refers to and relies on all past this is the only source of law. You cannot get around pre-contractual warranties, okay? So really dangerous thing, and yeah, well done for everyone who got that one. Is she entitled to damages for more than a 6 months notice? Well, good question, isn't it? And the answer here is absolutely, okay? Now, and the reason for that is this was her next up role. So she was stepping up from a state-based role to a national role. In recruitment land, if you are at state level, then you can only get to this role that you've got again. So there's a displacement period of maybe 2 to 3 years to get there, okay? So the damages that it takes you to get that new role, that gap, that's your loss. So unquestionably, you should have entitlement around 2 to 3 years of damages, possibly up to 4 years. And particularly in this one, when there are representations that go towards what bonuses should have been paid, which are unequivocally untrue.
Mm.
The last question is, if she found employment, could they enforce the onerous restraint of 2 years? The answer is no, because it was unenforceable anyway.
Mm-hmm.
So that was sort of a trick question. But even if it was correct and it was an enforceable restraint, no, because they repudiated her contract. She accepted the repudiation and therefore cannot be bound by what's called a negative pledge, which is a restraint. something that puts pressure. So in all ways, this was an incredibly stupid and dumb thing to do. And as I said, this is a set of facts that we deal with quite commonly. Okay.
Complex. All right.
So next week we're dealing with part 2. We're going to do OHS governance next week, and the week after that's our 50th birthday. So it's very, very exciting indeed. So we look forward to you next week. I promise that I won't stuff the technology next week, and I promise I'll read out the whole question. What are you going to promise?
I'll be better, and that's a lot of things.
Yeah, so I promise you will have slept by next week.
Yeah.
I think Karen needs to promise she's going to sleep.
Yeah, definitely. All right.
Okay, guys. Thank you very much.
Thank you for being so patient.
Cheers.
See you next week. Bye now.
Bye-bye.